September 26, 2012. This is Justice Done Dirt Cheap at the so-called Justice Building. I want to provide some information on the proceedings that occurred today. I'm scheduled to be in court for a plea hearing, and what happened was I had filed a notice of application and that corresponding affidavit and a brief in support of that, which challenged the jurisdiction of the court. Now, according to jurisprudence and established case law on the subject, one must file the application before the first plea hearing, because the consequences of entering a plea is one is considered to have attorned to the jurisdiction of the court. So as long as one challenges jurisdiction before a plea is entered, they have the option to actually appear by way of special appearance. A special appearance it's not a general appearance, it's a special appearance, so one can actually appear without attorning to the jurisdiction of the court for the specific reason to challenge the jurisdiction of the court, which is what I had done. I believe the court has no jurisdiction in this matter. They're not proceeding according to the Provincial Offences Procedure Act. And what's interesting is the lower court judge, which is the Provincial Court of New Brunswick, is considered lower court judges. And lower court judges, jurisprudence has established, they do not have jurisdiction unless jurisdiction can actually be clearly established through statute. Without a statute pointing to that jurisdiction, they have none, which is different than a Superior Court judge, such as the Court of Queen's Bench in New Brunswick, where it's assumed that they have jurisdiction unless it can be pointed otherwise. So, what happened with me, in my experience, is I've challenged the court on many facets. One, a summons to appear was issued by Judge Mary Jane Richards, and I'm challenging the jurisdiction of the court to even issue a summons to appear in the circumstances that are presented. And these circumstances are that a bylaw ticket for the City of Fredericton was issued by a City of Fredericton police officer, Corporal Matt Myers, and Corporal Matt Myers did not fill out a notice of prosecution, nor was there a date on the ticket that gave a court date if one wished to challenge the ticket. According to the Provincial Offences Procedure Act, bylaw matters come under the ticket procedure section. And under the ticket procedure section, it states quite clearly that a notice of prosecution must be served on a defendant at the time of issuing the ticket. If one refuses to sign the notice of prosecution, then that's noted in the notice of prosecution. Then the notice of prosecution is filed with the court. And the notice of prosecution must be filed no later than the date of the first plea hearing. So, the last hearing that I had was August 15, 2012. On that date, I demanded the court tell me if there was a notice of prosecution before her. Now, the court refused to answer my question. I asserted myself and ended up being dragged by my heels out of the courtroom. I was threatened with being charged with contempt of court, and that didn't happen though. I was just physically dragged out of the courtroom, and the sheriffs escorted me out of the building. Now, it's wrong that one is literally dragged out of a courtroom because they're asking some simple procedural questions, but that'll be dealt with later on. Now, coming back to today, the matter on the August 15 was adjourned to today because the City of Fredericton did not provide disclosure, and one needs disclosure to be able to answer the claims made against them. As a matter of procedure, the City of Fredericton does not provide disclosure until someone pleads, but one's entitled to full answer and defense, as stated quite clearly in the Provincial Offences Procedure Act. So one is supposed to have full disclosure before they even plea. The City of Fredericton, as a practice, has become, they just basically run this mill on, where they just give out a pile of tickets. Out of every 100 tickets they issue, maybe 1 or 2 people will even show up and contest it. The rest of the time they're just making money off these tickets. So the judge ordered that the City of Fredericton provide disclosure and set the matter over till today's date, which is September 26, 2012. Now, at the hearing today, just minutes before the hearing, the lawyer representing the City of Fredericton went ahead and handed me disclosure. Now, consider this is minutes before the hearing. How am I supposed to plea and consider all the information and disclosure if I only have minutes to consider that, and then I'm supposed to enter a plea? It's wrong. Again, this is another practice that they do all the time. They just shove a disclosure in your face 2 minutes before the actual hearing. And so what ended up happening was the judge adjourned the matter until October so that she could have time to consider the notice of application that I filed, supporting affidavit and brief in support of that, and so I have time to review the disclosure before that time and decide whether to plea or not. At that time, the court is going to decide whether I even have to plea at all, or not a have to, but if she's going to force me to plea, or she's going to dismiss the matter as I'm requesting in my application. So procedurally, the City of Fredericton has been going along here, and what's interesting is I even had it confirmed on the record today by the judge. There is no notice of prosecution in the file. So it's been confirmed by the court on the record, no notice of prosecution. We are entitled to due process according to the charter and jurisprudence, and if the City of Fredericton wants to hand out bylaw tickets, then they should do so according to the Provincial Offences Procedure Act. So far, in my experience, they are not. I even had it confirmed on the stand the other day by Constable David Beck that he's never issued a notice of prosecution in his entire career as a Fredericton police officer, and the Judge Mary Jane Richards admitted to never having seen a notice of prosecution. It's not the procedure that they actually follow in provincial court. So it's unfortunate that this is being revealed, that the judges, solicitors, the police are all moving along and not actually following proper procedure. Now, if people consent to go along with this improper procedure, that's one thing, but I have stated quite clearly on the record, I do not consent. I stated quite clearly, I am not attorneying to the jurisdiction of this court. I'm challenging the jurisdiction of this court. I don't believe the court can force me to do anything. I believe the court has no subject matter jurisdiction, no jurisdiction over the parties, and no jurisdiction over the issues because of the improper procedure the whole way along. So I'm looking forward to seeing how this all pans out. I'll put the links to the different documents in the description of this video so you can read along. It's a good read. The brief is quite to the point, and I think it's an enjoyable read. So hope you all enjoyed this video. This is the update, September 26, 2012. Justice done dirt cheap. Another day in court, dealing today with bylaw matters in the City of Fredericton. Thanks for listening. Have a great day.